and 5880-81-12 respectively. Counsel?
Ron Legault, Monroe County Public Defender's Office for Jimmy Nash. However, Your Honor, my client does have a request he would like to make to the court.
All right, I'll wait. Counsel,
All right.
I'll give the appearances on the record. Green Jones for the County Marion.
Robert Turner for the children, Keon Martin, Star Agent Nash.
All right, Mr. Nash, do you have an application?
Application?
Tell the judge what you
You have a
want.
request.
Yes, I would like to read some for the record, please.
Yeah, I believe he had a request specifically regarding his representation.
Go ahead.
This letter right here, I very much want to get this on record. If you just bear with me. It says, today I would like to be afforded my due process by placing both of my children back inside our residence we share and the residence that my children know and love so that we can reestablish what we've lost as a result of this system. I'm requesting to have the order of protection against me removed immediately so that Latoya cannot continue to use this as a platform, for her dispute. Latoya's actions in the past reflects her present actions of today. I spoke with my children once in 30 days after making over 20 requests to speak with my children. This is not in the best interest of my children and is cruel and unusual punishment towards my children who were residing in our own home prior to me being incarcerated for 6 days on unrelated charges. I would like this court to recognize this as cruel and unusual punishment towards my children, especially in the absence of any claims of abuse. This court has repeatedly...
Sir, if you would, I'm not trying to interrupt, but I want you to first address your representation by Mr. Lovejoy.
Okay, I'll get to that in 1 second. This court has repeatedly ignored my petitions as well as the facts stated in them. My due process protection was not afforded when my attorney was not effective when seeking to protect such a right. Today I would like to file an order to show cause as to why my kids should be placed back inside of their own residence we share until the decision is made regarding Latoya's visitational rights. Latoya needs supervised visitation with my children according to my petitions and the facts stated in them. I ask that before you keep allowing my children to be in an unfit mother's care, such as Latoya, that there be an order showing cause as to why my kids needs to be returned to their natural residence until this court establishes custody and visitation rights to either party.
All right, sir, I will let you know. You can file an order to show cause, and I will not predetermine the outcome of such an application before the court, but I will let you know I am always hesitant as a judge to grant relief upon an ex parte communication when there is a pending custody matter before the court. In other words, if I can hear from both sides, and I can't because this matter is pending, I wait to do so before I make any shift in custody. I understand what your concern is, sir. That's why you have also pending matters before the court. I will address those concerns in the pending matters before the court. I don't know that it would advance your case by an order to show cause. At this point, I see that Mr. Ludlow has represented you well, and I'm continuing to appoint him as counsel. You may proceed.
Ma'am, I do not want Mr. Luckbill to represent me. If I have to represent myself, so be it. But he is not effective. Neither petition that I have pushed forward have been on record.
Sir, just because you don't prevail in what you want does not mean your counsel is necessarily ineffective. If you are asking to represent yourself, I'll allow you to do so. You don't have the choice with your attorney, merely the assignment of competent counsel. The court has done so on your behalf. Are you asking that Mr. Luckbill continue?
I'm asking that Mr. Luckbill be relieved based on our conversation, based on the fact that he told me out of his own mouth, which I have recorded, you understand, that I need to charm over Mr. Robert Philip Turner, and that he also stated on record that Mr. Turner is friends with you and very well liked by you in your court. Now, this came out of my own attorney's mouth, and with that, I no longer need to be represented by him.
Sir, I have a professional relationship with each of you.
Okay, I understand that.
There are well respected.
I understand that.
And I will suggest, sir, that,
Well, if he's telling me straight up that I have to charm someone over in order to win anything,
Mr. Nash, would you, Mr. Ludlow, what is your application?
I would move to withdraw, Your Honor, if
Thank
he
you.
wants to represent himself.
I don't wish to represent myself. I wish to have another attorney appointed based on the fact that this man right here, with his own assertion, stated that basically I have no wins if I don't try to charm over Mr. Robert Philip Turner. I'm a grown man. I have no time to be charming another grown man. My kids are at stake right here.
As to whether Mr. Ludlow did or did not say that and what context it did not.
Well, I have it on record.
However, sir, wait. That is not the purpose of this court. The purpose of this court is to address the custodial dispute and to promote the best interest of your two children, Keon and Sorry.
Well, Mrs. Judge,
Wait, please, sir, do not speak over me. I'm going to ask kindly that you sit down. Thank you.
Thank you, Your Honor. Based on the information presented at the last court case, the court indicated that it would be seeking supervised visitation between Mr. Nash and, at the very least, Star Asia. There's an issue regarding Keon. Towards that end, I did send Mr. Ludlow a letter asking him to get me the names of his proposed supervisors. He did provide me with some names. I left messages.
you could save your breath. That's not even in the plans. And you contacted me yesterday.
I'm going to ask you to respect counsel
Yes.
in this court for not to speak over them.
Pardon me.
So I'm just indicating that I did not hear back from the proposed supervisors. I'm fairly certain Mr. Nash really does not have any intention of engaging in supervised visits.
Correct.
I wish he would consider it at least as a bridge to reestablishing contact between himself and his daughter, even if it's his own mother, perhaps. She might be an option. So I'm just hoping we can come up with somebody. I did also request paperwork, discharge papers from Mr. Nash's hospitalization on or about July 4th at New York University Hospital. I learned of that from Ms. Marion because he had left her. She had the doctor at that hospital called her early in the morning on July 4th, indicating he was there. I just wanted to see what those discharge papers were, whether it was a physical ailment or a psychiatric ailment or what it was. Again, in terms of my client, Star Asia, Mr. Nash's daughter.
And I'm sorry, Mr. Turner, and those papers, discharge papers revealed what?
I haven't seen them. I don't think they've been produced yet. My client, Mr. Nash's daughter, would like to see him. I actually spoken with Ms. Marion in the past. Despite all the hostilities, she doesn't feel that he would be a danger to her.
Of course you don't.
I'll just leave it at that. You know, in terms of the timeline and the history of the case, I will confirm that prior to Mr. Nash's incarceration, the children did live with him. They were on his DSS case. When I got the case, the children were with their mother. She retrieved them after his arrest. She was living in a shelter. She got DSS switched to her name. She's now living at a confidential address. I've been to that apartment. The children are settling in there. But nevertheless, you know, we should try and address visitation.
Absolutely. I agree, counsel, that we should address visitation.
We did establish that Mr. Nash is not the biological father of Keon, although Keon looks at him certainly as his father's figure, having essentially been raised by him.
So, as to Star Asia, let's have contact resume with which supervisor? Mr. Ludlow, who's available? You're the one that's supposed.
Ma'am, there's no plans to have nothing supervised. Let's stick to the. Can we discuss on record why my kids are residing with her right now before a judgment can be decided? Why my kids are not brought back in their own residence?
Mr. Turner has said your incarceration and your hospitalization included in preventing you from committing crime.
Okay, I was only incarcerated for 6 days.
Listen, during the pendency of this action, the court is allowing you to have supervised contact and wants you to have contact with Star Agent as soon as possible. If you would allow me, I will try to facilitate that today.
Wait a minute, one more thing. Because I was incarcerated for 6 days, this court decided not to bring my kids back home?
Sir?
Yes.
Yes, sit down.
Is that a yes?
Sir, I'm asking you to sit down.
And as a matter of fact, as far as me being in the hospital, Mrs. Ruhlman, Judge Ruhlman, I don't have any discharge papers. I don't have the resources, but I did try to retrieve them before Mr. Luckbill did, and they said that it would take 1 to 2 weeks. Now, I'm asking the court that, yes, facts. I have the paper right here. Okay, I'm just letting you know I sent off for my faxes for my release, and they're right here. Would you like them? Would you like to see them? You can see them. Now, Judge Ruhlman.
I'd like to focus on the issue, and that is to have you have contact in a safe setting. That is the mandate of this court, to ensure the safety and the best interest of your children, in particular your biological child, sorry. And so, Ms. Jones, is your counsel, is your client able to articulate the supervisor that she would allow father to have contact?
Pardon me, Judge Ruhlman, I have something that is very pertinent before you even go on.
No, sir, I asked Ms. Jones to stop.
It's regarding my hospital visit.
Sir, I don't want to get that now. Please be quiet. Ms. Jones.
Yes, we would agree to Ms. Nash's mother, who's Irene Simmons, being the supervisor.
And I disagree.
That's who we have proposed.
Thank you, Irene Simmons. And if your own mother, you will not allow her to supervise your
Of course not. She's the one that put my children in a shelter. Now, if I may say this, I have, for the court.
Your mother put the child?
Yes, ma'am, she did. My mom is a manic depressive. She's been that way all of her life. She's been dealing all of her kids the wrong cards all of her life. Judge Ruhlman, if I may just get this in, I promise you, you won't hear nothing from me no more.
Sir.
Thank you. I have, if I could show this court, because we don't have my discharge papers, I have it documented. I can show you video footage of me in the hospital from the time I was released. And it shouldn't take long. I can show you me in the hospital and me being released.
Evidentiary hearing or trial in any
You need evidence.
I'm not receiving evidence today, sir. I'm not having a hearing today. Rather, I'm continuing the temporary order requiring a supervisor for visit. It doesn't mean at a later date your attorney may not ask for a hearing, and I'll put it down for a date. But today is not a hearing.
You mean to tell me you don't want to see my proof that I was not in there for psychiatric reasons? I know you don't want to see it. Because it proves your ass wrong. That's why you don't want to see it. That's all right, though. Because it proves you wrong. That's why you don't want to see it. It proves you wrong. That's why you don't want to see it.
Sir, I'm going to ask that you stop addressing the court, sit down, and you remain. Otherwise, we'll keep it out.
Well, you can listen. You've been doing everything without me, anyways. You know, so keep doing whatever you've been doing. I ain't got no rights. You gonna see y'all ass. YouTubing, you heard? YouTubing. Motherfuckers think y'all can do anything they want to do, yo. I don't believe this shit. Y'all see this shit, America? Again. Same shit. Same shit. I tried to prove to the courtroom through video footage of why Mr. All right.